Well, we're going to know by Monday if the Supreme Court takes up the appeal of a college lacrosse player convicted of beating his ex-girlfriend to death. A jury found George Hughley guilty of killing Yardley Love in her dorm room 5 years ago at the University of Virginia. It was a huge case. We covered it wall to wall here on Happening Now. Hughley insists now that his rights were violated when one of his lawyers got sick and missed part of the murder trial. In the meantime, Yardley's mother is suing him for $30 million. That court case is scheduled for 2017. But the more immediate issue is this appeal to the Supreme Court. Ebony Williams, attorney and Fox News contributor, joins us, and Whitney Boan, criminal defense attorney. It's nice to have you both. Ebony, will the Supreme Court hear this case?
Jenna, I really cannot possibly see it. To call that a long shot would be a gross understatement. There's just really not any valid reason here. Let's look at the Sixth Amendment, if you will, for one moment. It talks about protecting the right to a fair trial. There's no evidence that suggests that this guy did not get a fair trial. He had not one but two lawyers. His claim is based on the fact that one lawyer became ill and missed some days of trial, but the judge in that trial said, we're not going to continue this case to wait for your other lawyer to get well. You've got a viable, competent lawyer who's ready to move forward, and that's exactly what happened. The second part of a Sixth Amendment challenge is you've got to prove prejudice. You've got to prove that not only was your counsel inadequate, but that actually affected the outcome of the trial, and I just don't see evidence of that case.
Interesting. Whitney, I'm curious your perspective as a criminal defense attorney. As the team, there was a team of lawyers, and one of the attorneys on the team actually did say in court, well, I can't continue for the team. So Hughley's own people said it was okay at the time. Does that hurt his chance further for appeal?
Well, I think it does to some extent, and I agree with Ebony. You know, the issue here as far as whether or not the U.S. Supreme Court is going to accept jurisdiction to hear this case is whether or not there was any actual prejudice, and I'm not seeing where there actually was any. However, that doesn't mean that there isn't enough here that his Sixth Amendment right to counsel was not damaged by the fact that one of his attorneys was sick, was out for a number of days. You have to keep in mind, you know, when we're attorneys and we're preparing for these trials, especially when we're working with co-counsel, we'll split things up. You know, we'll split witnesses up, we'll split up different topics that we're going to be arguing, and when someone else has to jump in at the last minute, that could put them at a disadvantage and therefore put the defendant at a disadvantage. I do still agree with Ebony, however. I think that this is not likely to get to the U.S. Supreme Court just because I don't see how he was actually harmed by it. I see that one attorney said, yes, I can do it. Hughley then objected to it, I think, and then said, you know, I want a continuance. I do want to not go forward without the other attorney. But the judge had to weigh judicial efficiency with his rights versus, you know, are we going to do this again, bringing all these jurors in here?
I'm going to have to take a quick commercial break. Hughley is facing more than 20 years behind bars. So this is part of the reason that he's trying to figure out any way not to go there. I want to ask you about the victims' families after the break and the $30 million lawsuit. We're going to talk about that price tag in just a moment.